I'm delighted to be part of this interesting conference, and I've enjoyed listening to many of the presentations yesterday and today. And in fact, this is an example of a successful cross-border cooperation, isn't it? Your project and this conference, this hybrid conference, and as to myself, I'm following this from Italy. We're in the mountains. And my connection is hopefully stable enough. But my focus, I want to emphasize in my comments, will be on cross-border regulatory cooperation, but I will touch on some of the subjects which have been mentioned. And I do not have any ambition to present concluding remarks. There is another speaker behind me, but that's okay. I have submitted a paper which is a further version of a speech presented in December, but I will highlight some elements from that and combine them with others. So the first point to make is that data protection rights and principles have maybe very interesting, but amount to very little if they are not complied with in practice by responsible controllers. And that is so obvious, but is often overlooked. The controllers are in fact those who are delivering the protection in practice, be it in the context of AI or other ICT applications. Now, many controllers do this voluntarily, but not all, and their self-interest may lead to suboptimal, so to speak, activities. And this is how the principle of independent control and supervision is part of the landscape. Supervision in its various forms, starting with raising awareness, giving guidance, dealing with complaints, but also inspections, enforcement actions, and the whole gamut. And as such, this is clearly emphasized in all the latest versions of data protection frameworks, the GDPR, Convention 108 of the Council of Europe, 108 plus, the OECD guidelines, all emphasize in special parts the importance of regulatory interventions in various forms. And in fact, the European Union's Charter of Fundamental Rights makes this independent control an essential element of the right to data protection. Now, the point is, and that's relevant for our discussion today, that the powers of data protection authorities are typically based on national law. And therefore, they also are limited by the scope of national law. And they are also, in a way, hampered by the differences in various national laws. That means that where there is a need to cooperate across borders, and that need is increasing, and many examples have been mentioned of such a need, and it's inherent in the way our technological ecosystem is structured, that they are confronted with a lack of consistency, a lack of common rules, and to have a productive cross-border cooperation of regulatory authorities, you need at least a minimum of that consistency and common rules, not in theory, but in practice and also in legal realities. In the context of the GDPR, and that is obvious, the EU framework provides for the EU member states such an environment, and more than an environment, it also presents obligations to cooperate to have joint investigations. There is a system of conflict handling, coming to consistency. There is the board, there are lead authorities, one-shops, and the whole ecosystem as you know it. And the ICO has been a very active participant in this up to the moment where Brexit took place. It was not only active, it was a highly regarded participant. It was a leader. It was the chair of the enforcement working group, for example, but it was an active participant in many other activities of the board. Brexit changed that altogether. Of course, this also was foreshadowed slightly in the last years, but beyond Brexit, that is a change. Now, so it happens that the ICO has, in fact, way before Brexit, but certainly also since that time, on the basis of its international strategy, invested in international frameworks, more widely, global frameworks, beyond the European Union, to promote cooperation where possible. And the forum in which this has happened was the International Conference of Data Protection and Privacy Commissioners, which is now known as the Global Privacy Assembly, with more than 100, in fact, more than 130 DPAs members. And within the context of this global assembly, an arrangement has been developed and adopted by a larger number, an increasing number of DPAs, which is subtle enough to allow productive cooperation, provide this minimum basis of cooperation. It's the Global Cross-Border Enforcement Cooperation Arrangement. Mind you, this is not an agreement, it is not binding, it is an arrangement for voluntary cooperation, but it contains all the elements to create a sufficient level of commonality and trust based on international principles, and of course, taking into account the needs of the DPAs cooperating. And the typical architecture is that on the basis of this arrangement, DPAs who want to cooperate enter into bilateral MOUs. The ICO is a member of party to a number of those MOUs. And one I discuss in my paper and mentioned in December, it was the case of Clearview AI, a rather big, quite successful company specializing in faces, face recognition, raising a lot of difficult issues. And the UK ICO and the Australian authorities, among others, have done a joint investigation, which came to conclusions end of last year, November, which will be finalized in the course of this year. Among them, the ICO imposed a provisional fine, if I recall well, of £17 million. So this is something which has a real impact. It has a real importance, and it is workable. Now, if we now move to the EU and Brexit, a relationship after Brexit, then the key word which you can see in all those relevant documents is appropriate measures for cooperation. This is mentioned in Article 50 of the GDPR, appropriate steps to come to cooperation. It was mentioned in the political declaration, appropriate cooperation. It is mentioned in the TCA at various places. But this has not been made much more concrete since. We're still waiting for this to happen. Meanwhile, as you all know, the adequacy decision was adopted too, in fact, on the GDPR and the law enforcement space. It has been referred to a number of times, including the fact that this adequacy decision has a sunset clause of 4 years and possibility to revoke if necessary. I refer to various models of cooperation in my paper. Summarizing this, I think the ICO is really interested in developing an agile and flexible and efficient, focused form of cooperation. And in theory, there are two models. One, a centralized, more integrated system, which basically links to and builds on the existing GDPR, including the board and the one-stop shop, and there are different varieties you can think of. And the other is a more decentralized, loose-knit, typically built on bilateral relations and the MOU. In other words, the approach developed within the context of the Global Privacy Assembly. And there are hybrids. You can think of partial this and partial that. That is not so difficult. So in effect, there are options to develop. Is there a scope for cooperation? Oh, absolutely, yes. Is there a wish and a need? Oh, absolutely, yes. And this is not one-sided, it is happening. I refer to the ongoing practice with the Irish authority, rather obvious, but also bilateral relations with a number of other EU member states, currently informal, and they range from Germany, Netherlands, France, and a few others. And in fact, in principle, all relevant relationships. And this is currently based on the, of course, very welcome fact that the legal frameworks are still very, very close. And it doesn't need much acrobatics to develop a bilateral relationship which is workable. Now, all this is, of course, linked to the proviso, which some of you have already referred to in various contributions, and that is the ongoing adequacy. It has been highlighted that adequacy means essential equivalence. And let me slightly unpack this. That means certainly not carbon copy GDPR. It doesn't mean identical. It doesn't mean quasi-identity. It means essential equivalence. And essential is a word which does two things. It emphasizes a certain flexibility, and it also emphasizes that on the essence, the essential principles of data protection, there should be equivalence. This is not something I have invented, far from. And the Court of Justice, in two very prominent decisions, has emphasized it itself. And the Schrems 1 and 2 are there to explain. If you reread carefully the Schrems 1 decision, the court also gives an interesting example. It says voluntary certification under the former safe harbor system is not a problem if it is compensated with very active and very effective supervision afterwards. So that said, and the court says, this is apparently an aspect of implementation. There is flexibility there, provided that the results in practice are identical. And the measure is EU law as read in the light of Article 8 of the Charter. So the essential principles will be decisive. If you go through the GDPR, there are various elements which you could respectfully refer to as fringe elements, and there are essential elements. Among those essential elements, I would certainly say, yes, essential elements is, for instance, the principle of independence, a legitimate purpose. If a legislator would say, well, you know, that's not so essential, the legitimacy of a purpose. It's if parties like it, okay, let them do it. That would certainly be an example of something unacceptable. Or the principle of fairness, the substantive principle of fairness, although not expressed in Article 8. I think that now, so flexibility within limits. And interesting is that the GDPR itself refers to Convention 108 plus. This is in the preamble. To my knowledge, the UK government has expressed a wish to continue to have high world-class standards. So there is this ambition to stick to the margin, and that, of course, is also read next to some language which sounds more like hoo-ha, we're going to wave the flag bravely, etc. The Information Commissioner in her response to the consultation has emphasized those points in the introduction. Independence and fairness is mentioned, and there would be other examples. So I think we need to be mindful that there is a distinction to be made. There are crown jewels, there are essential principles, there are important things, and there are less important things. Now, don't ask me now to exactly specify where the line is, but that's the idea. Now, I was tempted to, and if I have a few more minutes, I want to react to things which have been said yesterday in an interesting, in a very intelligent presentation on under the title, "Is this a missed opportunity or not?" And I thought that actually the part on personal data was a bit too pessimistic and overemphasized. My analysis is that this concept was explained very early on by the then existing Article 29 Working Party and emphasized by the board since. And all the elements of that paper have now been integrated in case law by the European Court of Justice. That is the relating to, the identifiability, etc. And yes, that's far-reaching, but it doesn't cover everything. If data do not relate to, that is, are not about or intended to affect the individual, nor are identifiable, then they are outside the scope. And that is a given in a lot of other legislative discussions right now in Brussels. But while they within the scope, and I agree that the scope is increasing with technological development, then it also only means that the protection applies. It doesn't mean it's not permitted, it means that the principles apply. And there, I'm cutting this now short, is part of the principles are they need to be applied on a risk-based analysis. So the elements in that paper distinguishing all different levels of risk, quite complex actually. If personal data is complex, I submit. The risk assessment is also rather complex. But it makes an enormous difference whether this is a threshold condition, a first question to be answered before anything applies, or whether you apply this in the context of those principles. And just to make the point in another way, would the idea be that a right of access, a right to know, a right to challenge would depend on there being any risk at all? Then I think we have a very unfriendly, unpleasant, and very unproductive, counterproductive system of protection. By making sure that it applies under personal data concept applying, then the next question is, what is the accountability? What is the responsibility of the controller to build a privacy respective system? I would very much advise to further develop this risk-based analysis, but within the context of personal data applying. And that has been the international consensus. This is why actually all those instruments converge. But there is a crucial point, and this is my very last comment. I want to draw your attention to this. The OECD guidelines do follow the idea that they only apply when there is a risk, when there is a danger for risks. It's one of the first provisions, I think 4 or 5, somewhere there. And they also do not contain the principle of legitimate purpose. It's not so obvious, you need to reread it, but this is one of the distinctions, one of the red lines. The GDPR and Convention 108 contain both, and that is why it is so helpful that the GDPR refers to Convention 108 plus as one of the sort of the yardsticks, and I'm quite not only hopeful, but actually I trust that at the end of the discussion in Westminster, there will be a creative way to come up with a UK version, which is within the margins of the, and if not, that risks to create major obstacles in international cooperation and in commerce, etc. Thank you.